Okay, good morning, everyone, and welcome to our webinar on cross-border legal and tax issues in the age of COVID-19. We are joined today by Rich Weiner from our International Department and Ken Levinson from our Tax and Business Planning Department. And we will begin the presentation now. So thank you for joining us. We will have a Q&A chat feature open. So if you have questions, please submit them through the chat. We will be monitoring those throughout. And then towards the end, we will address all questions that are submitted. If in any chance we don't have time to address a question, we will make sure that we are following up with you shortly after the webinar. So from that point, we will turn it over to Rich.
Thank you, Rich, and welcome everyone to this Frederickson & Byron International webinar on cross-border legal and tax issues in the age of COVID-19. As Rich mentioned, my name is Rich Weiner, and I'm an attorney in our International Corporate Department. And I'm going to spend a few minutes today talking about cross-border legal issues in the age of COVID-19. And then after that, I'm going to turn the webinar over to my colleague, Ken Levinson, who's going to talk about cross-border tax issues in the age of COVID-19. So as you may imagine, the last couple of months, the world has changed for cross-border transactions. And those of us who practice in the International Corporate Department have seen several new trends. And I'd like to talk about some of those trends today. The trends seem to be classified into three major buckets: contractual issues, governmental issues, and economic issues. And I'd like to talk a little bit about each one of those. And then I also have a slide, a very short slide about data privacy, which is kind of interesting. If I have time, I'll get to that, but we'll see. The first I'd like to talk about is contractual issues that we're seeing huge impacts in the age of COVID-19. And the first trend we see that, as you may imagine, a lot of companies overseas are trying to renege on their deals completely. That is, they signed up deals before COVID-19. They are in the process of performing their obligations under those contracts. And now with the onset of COVID-19 and then the economic downturn in many countries, economic recessions, depressions in some countries, a lot of companies around the world want to walk away from the contracts. So the first thing we've noticed, the first trend we noticed is a lot of companies around the world are trying to invoke force majeure. So for those of you who aren't familiar with force majeure briefly is an event that happens that's unforeseen on the date of signing of the contract, which is completely out of the control of both parties to the contract, which makes it impossible or virtually impossible for the parties to perform the obligations under the contract. And so at the beginning, the first couple of months of COVID-19, a lot of courts were sympathetic to parties that said, look, no one saw this coming. This was unforeseeable, completely out of our control. So we can't perform under the contract, and so court, please let us out from under our obligations in the contract under this force majeure defense. And many countries around the world, that was a pretty powerful argument, and a lot of courts were sympathetic to that. But we've also noticed that over the last couple of weeks and months, courts have been less sympathetic around the world to this force majeure defense. And that is because the courts are saying, yes, of course, this was unforeseeable when it started. No one could have predicted a worldwide pandemic, but you saw it coming. You saw it coming to your country. As it spread across the world, you saw it coming to your country, to your city. And so it wasn't completely out of your control to do something. You could have sped up performance. You could have hired more workers to get the job done sooner. You could have visited the project site or the work site or whatever it may be. You could have done that earlier, and you didn't. And so we're not as sympathetic to letting you out of the contract under force majeure defense. So we're seeing some of that play out around the world. For those companies that haven't invoked a force majeure defense, some have, some have tried to terminate a contract because they're going bankrupt or they're claiming insolvency. And if there's a clause in the contract which provides for termination for bankruptcy or insolvency, a lot of companies around the world, as you might imagine, with the economic downturn such as it is, have claimed termination for insolvency. So we're seeing quite a bit of that in a lot of countries around the world. But there are some companies that that obviously are in economic rates, but not to the point of bankruptcy or insolvency, and they are not claiming termination for insolvency or bankruptcy, and they're not claiming force majeure, but what they are simply saying is, look, we can't perform all of our contracts. We can't, our resources are scarce. We don't have enough funding. We don't have enough personnel now. We've had to lay off workers. We can't get to project sites. We can't get to meetings, whatever it may be. So we simply can't perform. So we are telling you now that we are breaching the contract. We are simply breaching. We are in violation. We acknowledge that we're breaching the contract. And if you don't like it, well, you know what? Come on down and sue us. Come to our country and sue us and see how that works for you. Because in a lot of countries, as you may imagine, the court systems have slowed down quite a bit as well. Either the courts are completely shut. In a lot of countries around the world, they're simply shut down. In some countries, they're just dealing with cases relating directly to COVID-19, to coronavirus. And in some countries, the court system is working with a skeleton staff. So they've pared down their own personnel. And so a lot of companies are saying, yes, I'm not going bankrupt, I'm not going insolvent, I'm not invoking force majeure, but there's nothing I can do. So come and sue me here in my country and see how that works for you, because that's going to take you a real long time to get in front of a judge to hear your case. And so the truth is that your relief may be many years in the future. So we're seeing quite a bit of that. For those companies that are not completely reneging on their deals, a lot of them want to renegotiate their deals. So they're using this coronavirus period as leverage. What they're saying is, look, our resources are more scarce now. We can't do your project, can't do on your deal in the time frame we wanted for the price that we had already agreed upon. It's going to cost more. So we need to renegotiate the price, or we need to renegotiate the time period during which we are allowed to perform. And the warranty period we were going to give you, well, we can't provide you warranty service. We don't have the personnel for warranty service anymore. We need to cut back our warranties or our warranty periods. And so we're seeing a lot of renegotiating of basic terms and conditions of deals that had already been signed up and already been agreed to. And we're seeing quite a bit of that as well. We're also seeing some companies try to cut back on their exposure, their risk exposure as well, saying, okay, we're going to renegotiate this, we'll do your deal, but on this $50 million deal, we want a cap on liability of $10 million. And we're also seeing companies resort to arbitration quite a bit as alternative dispute resolution. So as these breaches come up and as these disputes arise, we're seeing an uptick in arbitration around the world. For governmental issues, we see in general either a slowdown or a stoppage of anything that has to do with government agencies. So if you wanted to bring your raw materials into the country, or you wanted to, your supply chain materials, whatever it might be, we're seeing a slowdown in general for customs around the world. Especially in those countries where customs service their personnel has been cut down, and there's been quite a delay or stoppage in the movement of goods from one country to another. We're also seeing countries that are putting export controls or export requirements on finished products that are going out of the country, especially if they are considered essential goods for that country. And by essential goods, I don't mean just the PPE and respirators and ventilators designed to fight the virus, but also any goods that a country determines are essential for its populace. And so we're seeing a new and heightened export controls and export licenses required to ship goods, finished goods overseas. We're also seeing a delay and stoppage of movement of individuals. As I'm sure all of you are aware, a lot of borders have been shut down. So our border with Canada has been shut down. Our border with Mexico has been shut down. A lot of borders around the world have been shut down. There are some countries that are starting to open up this month, but this is still an issue. So for those contracts which require business meetings, meetings at project sites, meetings at facilities, meetings at the other party, with the other party, trade shows, all of that obviously shut down. All we have left really during this period is Skype and Zoom and the like. And so there's been a near stoppage of cross-border movement for individuals. And that's also true for employees. So for those companies that had wanted to, for example, set up a subsidiary in a foreign country and then send their employees over to man the subsidiaries, we see a lot of slowdown or stoppage there. One, because they can't get the appropriate work permit or work visas from the immigration service in the country. And then just in general, anything having to do with government agencies or ministries, that has slowed down because a lot of those approvals have either been shut down completely, or again, the ministries or agencies are working on a skeleton staff, and so things have slowed down quite a bit there. So anything in your deal that requires approval from a government ministry, I mentioned a few here on the slide, that's taking much longer. So if your deal requires the transfer of technology from one country to another, we're seeing quite a bit of slowdown in government approvals to get that done. Government ministries are very slow. IP protection, patent filings, for example, or as I mentioned, if you want to incorporate another country for a subsidiary or open a branch office or do a joint venture, we're seeing government approvals really slow in a lot of countries around the world because government agencies have slowed down quite a bit as well. And then finally, I want to talk about economic issues. And economic issues is really interesting. Being diametrically opposed trends here, mutually exclusive trends. So in some countries that are feeling the weight of the economic downturn, economic recession or depression, some countries are taking the position that we should entice foreign businesses to come here. We should entice them to come and help our economy. And they will increase business, they'll hire domestic workers, they will help our domestic economy. And so therefore we should lower the barriers to entry for foreign companies to come do business here. We will decrease capitalization requirements. We will make it easier for them to get loans, and we'll try to entice them here. Some countries are doing the exact opposite. They're taking the position that if foreign companies come in, they'll be in direct competition with the domestic companies that are already having a tough time in their economy, and therefore that might hasten the day in which the domestic companies actually go bankrupt or have to claim insolvency and go under, and then all of their workers will have to be terminated. So for those countries, we're seeing an increase in capitalization requirements to do business, more difficulty to get loans if you're a foreign business. We're seeing so two diametrically opposed trends on either enticing foreign companies to do business or telling foreign businesses to stay home in sort of a protectionist mode for the domestic industries. And specifically in terms of M&A, we are seeing in some countries, we're seeing a relaxation of competition or antitrust restrictions. So if you're a foreign business and you want to acquire a business in a foreign country in your industry, before the coronavirus, it may have been in violation of that country's antitrust laws or competition laws. Now some countries and courts are taking the position that, well, this domestic company is going to go under. It's going to go bankrupt. So better that it should be acquired by a foreign company and continue doing business and retain all of its workers than going bankrupt and terminating all of its workers. And so relaxing those antitrust and competition restrictions known as the failing defense exception. And with that, I do have a slide on data protection, but I think I'll save it for, do I have time for data protection? Sure. No, Ken, I'm going to let you talk. So I'm going to turn this over to Ken Levinson, who, although he isn't in the same background, is actually sitting right next to me physically. So I'm going to turn it over to him and let him talk about cross-border tax issues in the age of COVID-19.
Thanks, Rich. It's very generous of you to skip a slide.
Thank you.
Those of you on the
We can come back to it later.
don't necessarily know that. That's true, we can. So the issues associated with COVID on the tax side are quite diverse. And one of them is starting off with sort of the income tax issues, which talks to the overall question about whether the federal tax, the rules for federal taxation and some of the exceptions on reporting and things like that that are coming out now affect the states, or whether the states diverge from that. So when it comes to conformity, we'll come back to treaties in a second. When it comes to conformity, states generally follow a couple of patterns. Either they have what's called rolling conformity, which means they essentially automatically conform to federal law as and when it changes. They have static conformity, which is, so rolling would be an example of North Dakota and Iowa. Static conformity means it takes specific action. So as of a point in time, as what federal law is, that state conforms to that law, but it takes another specific statutory adjustment by the state in order to move up or to then pick up the subsequent enacted laws. And Minnesota's a good example of that. Then there are some states, Pennsylvania happens to be one, where they simply don't conform and they'll pick and choose a couple of provisions, again, subject to state law, but there is no automatic conformity either by time or by subsequent event. But all states participate in what's called decoupling. So they will take, even though they generally conform, they will accept some of the federal rules from state application, because they either don't believe in that, or the revenue hit's too high, or there's a complexity in application. But a good example would be bonus depreciation, 100% expensing that's now in place, moving QIP property federally. Not all states, in fact, many states do not allow for state income tax purposes bonus depreciation. Similarly, there's a wide diversity of views on the states on the deemed income under 965, the repatriation rules. Most states actually, numerically, did not tax the deemed income in 2017 that came from TICJA. And then there is the issue about all the catch-up legislation. We've got the TCJA has finally had a lot of states deal with at least the substantive provisions to the extent they've enacted statutes, again, Minnesota being a partial exception to that. But the CARES Act, with the PPP issues, the NOL issues, the QIP, the expensing question, the HEROES Act. So there's a lot of issues that are still in flux because the law has changed and the states haven't always caught up to it or made intentional decisions as to whether or to what degree they're going to conform. A good example of this is residency. The federal residency, this is non-resident aliens as to whether or not they trigger the 183-day formula that we have to make them U.S. taxpayers on a worldwide basis, making them resident aliens. And the states, as you know, have very different rules on when one becomes a state resident or not. So even if they conform federally overall, the state residency rules may actually be different as to whether an individual happens to be resident of a state in a given year under the state's law. And the COVID situation is aggravating these disparities, because the IRS has statutory authority to say that when a non-resident is unable to leave the states federally for a medical condition that arose while present, they are excluded from the day count associated with that medical experience. But they can't exclude days that count if the situation, the medical situation, existed before the person arrived and they were aware of it. Think of the COVID dynamic federally. A lot of people who either came over or who overstayed because of state stay-at-home issues. Now, the federal law, as a notice 2020-20 by the IRS, says they can exclude 60 days of presence at the taxpayer's election anytime starting between February 1st and April 1st of 20. The states, though, have not come to grips with this by and large. And so you may have people who could exclude 60 days and hence fall below the 183-day calculation federally, but may still be considered resident of a state. And we're going to have to see how the conformity rules emerge in these particular cases going forward. Then, of course, there's a separate state rules. They are not subject to the tax treaty. So if a foreigner directly sells into the state, they may very well have state sales tax or use tax obligations, or there may be the marketplace under the Wayfair So there's a whole bunch of state issues that are separated from federal that people need to be very focused on. We're going to have to watch legislation and announcements going forward to see exactly how those are harmonized. Transfer pricing, I know people saying, why are you talking about transfer pricing? Well, you know, the essence of transfer pricing documentation that is required to be in existence when the returns are filed requires that you justify and document the related party transactions that you have, whether it be by margins or rates or some other form of sales price. But you need to update those studies every 2 or 3 years maximum. But in COVID, because the comparables may very well have changed, given the environment that Rich was talking about, we have a situation here where you don't have to wait the normal 2 or 3 years to update your transfer pricing studies. To the extent that COVID impacts your prior documentation and your prior rates or return positions, and you have either better comparables or you have an alternative method that better describes the situation, in your case, you can change your transfer pricing study and documentation because of COVID. But see, if it doesn't work to your advantage, change, you stick with the same normal cycle. But watch out and take advantage of transfer pricing documentation changes if, in fact, you can. Attorney-client privilege is an area where we're still getting into overlaps between federal, state, and foreign. As Rich well knows, the international rules on attorney-client privilege are very different from the U.S. rules. The U.S. has a fairly robust attorney-client privilege. The foreign countries do not have quite as much protection, but the states, although the attorney-client is generally recognized in the states, as you can appreciate, the federal accountant-client privilege is far more limited when it comes to state application. And so we have situations where under the state law, you have cases where the states may allow the accountant-client privilege, but only if it's provided in their statute. And there are other cases where it's a matter of sort of state common law, but it's limited as to who gets to apply it. So in some states, when it's not a statutory right, it's up to the accountant to assert the accountant-client privilege for state purposes, and in other cases, up to the client to assert the privilege. So, and then when you go abroad, of course, you may not have the same privileges. So on the transactional stuff, on the international side, you've got kind of 3 sets of rules that come with protection of documents and communications. And you need to make sure that you're aware of that. Now, the COVEL structure is one where the accounting firms bring in the law firms bring in the accounting firms on attorney-client privilege, and the accounting firms or other experts work for and under the direction of the law firms. And those are still available. They're not necessarily subject to the same protections abroad. So again, if you're dealing with audits or transfer pricing issues or some other form of contractual dispute, you need to make sure that the communications between the clients and the lawyers and or the experts are protected to the maximum extent possible. And as you probably appreciate, anytime you're getting into the area of potential criminal tax exposures, we would certainly urge that you bring attorneys involved not only for the protection of privilege, but also to some degree that will help you prepare the record for what's going to happen going forward and have a continuity of representation throughout. And this is also true in the uncertain tax position. So there's a lot of uncertainty around, as you can appreciate, and many of the people on this call, this webinar, operate with a high degree of responsibility for advising clients on areas which are not so clear. That's what we get paid the big bucks for. But in terms of the combination of counsel and accounting firms, which I think is really a point of collaboration, counsel can help provide tax opinions and legal analysis that the accounting firms themselves or their clients can rely. Counsel is also available to help to assess whether somebody has non-willful behavior. We see these issues a lot in the voluntary disclosure cases because you can go through some of the streamline programs. If you're non-willful, you can be foreclosed from them if you're not. And frequently it's a question of whether the taxpayer in that case is or is not non-willful, was something that the attorneys tend to evaluate. We are, as you are, and the accounting side, our second set of eyes to help each of our professional positions get comfortable on issues. Having somebody else to bounce things off of who's independent certainly allows the primary requester to get additional assistance or confirmation, or for that matter, to have to confront issues or questions that might get raised by an auditor. And then, of course, there's the issues about how to draft some of the UTP and FIN 48 disclosures, helping evaluate more likely than not determinations. Again, there's assistance that can be provided. The one thing I want to be really focused on is the involvement of attorneys in the marketplace for return review has to be carefully circumscribed, because most law firms do not tend to become preparers under the federal law. And so that line gets somewhat gray depending on how much detailed review is done or otherwise. And I think both sides want to make sure that nobody backs into those responsibilities and possible penalties inadvertently. We talked a little bit about this before on the tax controversy issues. The privilege obviously protects communications, not only with the clients, but with the accounting firms, with experts. Showing if the IRS or some state auditor comes up with a very aggressive position against the clients, bringing in counsel can very well demonstrate the client's seriousness and determination in defense of their position. We mentioned before that having lawyers brought in early, at least on an issue basis, can provide continuity of representation and establishment of the record. But at the end of the day, the biggest issue is the collaboration between the professional firms. We each have our own functions. The law firms don't prepare and don't audit, don't prepare returns, don't audit financial. And on the other hand, we can help provide teaming or collaboration with the accounting firms. And together we help provide, I think, the best results for our mutual clients. And since we have a couple minutes here, let's go back to your slide, Rich.
Sure.
Okay.
Happy to.
Privacy.
So just very briefly on data privacy. This is actually quite a very interesting trend we're seeing in international business transactions as well. Sort of a tension between individual rights and a government need to collect information about those people, workers who have been afflicted with the coronavirus. So there are some countries that are taking the tack that employers absolutely have the right to collect information about workers who have been afflicted with the coronavirus, and then also do their own contact tracing. That is, the employers in various countries around the world have the right to inform other employees in that company that they have been in contact with an employee who now does have the coronavirus. In some countries, the courts have taken the opposite view and have said the employer is entitled to gather information about the individual employee who has been afflicted with the coronavirus, but in the interest of individual rights and confidentiality, the employer is not entitled to disclose that information to any other of the employees, making it much harder to do contact tracing. So an interesting tension, an interesting fight I see in various courts in different countries around the world on how to protect individual data privacy, especially with regard to health information, but at the same time protect other employees so that a company doesn't find itself losing half of its work staff because they can't explain to other workers, other employees that someone in the company now has the coronavirus and they need to take precautions.
So I've got one point I want to just go back and make sure. I think I had alluded to the fact I was going to talk about tax treaties and the conformity environment. I just want to pick up one point on that. Rich Bracken, I'm surrounded by riches, or a surfeit of riches here today. But Rich Bracken, if you've got some questions, that's fine. But let me just pick this one point up and then we can turn back to you. And that is on the nexus question. So the state nexus rules obviously depend on state law. We talked about that. That's sort of self-evident. But when there is nexus for state purposes, either because of sales tax or income tax, it's either transactional, I've sold enough goods into the state that I trigger the Wayfair marketplace or specific transactional reporting and tax obligations in the state, or the entity has sufficient footprint in the state to trigger income tax liability. With respect to a foreign taxpayer who's dealing with the U.S. on a federal basis, and there's a tax treaty, the linchpin is what we call permanent establishment. So business profits from the U.S. generally have to be connected to a permanent establishment as defined in the treaty. But if that linkage occurs, the liability for federal reporting isn't what we call an enterprise reporting, which is not just the taxpayer, the legal entity that triggered the problem, or the transaction that triggered it. It's all of the business-related entities within the structure that may themselves have some connectivity. So on the one hand, state-wise, you're looking at, transactional or entity-specific nexus and reporting obligations that result. From the federal standpoint, using a tax treaty structure, you end up with the enterprise-wide exposure if they violate the tax treaty permanent establishment rules. Rich Bracken, have you anything for us?
No, this has been fantastic content. The Q&A is open. If you have any questions that you would like to put into the Q&A, that would be fantastic. And I'm not sure who's driving the presentation, but if you want to go to that very last slide, we'll make sure that the contact information is visible for any follow-up questions. And we'll keep an eye on the Q&A. And as we're waiting on questions to come in and we land on the contact slide, what I do want to draw your attention to are the QR codes beneath both of our presenters. And if you are on the LinkedIn platform and you have the LinkedIn app, you can scan this QR code to connect with either one of our presenters by opening the app, going to the top search bar. To the far right of the search bar, you will find 3 boxes and an X. And upon clicking that, you will bring up a scanner. Simply hold that up to your screen and you will be able to go directly to either our Ken or Rich's profile on LinkedIn and connect with them directly. You have a wealth of information on this topic past the content that they've shared today, so feel free to reach out to them, or you can call them or email them at the contact information listed there as well. And gentlemen, it looks like you were incredibly thorough in the shorter timeline webinar that we've had today. It looks like we don't have any questions coming in, but I do encourage any and all participants to connect with Rich and Ken on LinkedIn and or connect with them through email or give them a call if you have any questions on this topic. Excellent. Gentlemen, thank you both so much for your presentation today and the content that you've shared, and we will look forward to connecting with you in the near future.
Great.
Bye all.
Thank you, everyone.